An issue here.
You're live.
Hey everybody, thanks for joining us today. We're working through a few issues with getting the slides up and running, but we'll have those ready for you in a second. And just bear with us for a moment. Thanks. And what I can do actually as we get this going is I can just let you know. So this is Matt Staples. I'm a partner here in the privacy and cybersecurity practice at Wilson Sonsini, based here in Austin. I'm joined by my partner, Jan. Jan, do you want to introduce yourself briefly?
Sure, thank you, Matt. I'm Jan Dont. I'm a partner at Wilson Sonsini, and I'm based in Brussels. And I'm the co-lead of the European data privacy practice here in Brussels.
Great. So we have some slides for you today. We're getting those up and running in the background. We're getting some help, so apologies for not having those for you yet, but we'll have them. As some background information as we do that though, Zoom lets you post some questions in Q&A, so feel free once the webinar gets going to put those questions in. We'll try to get to them. Interestingly, there's been a lot going on, as you'll hear about today, especially on the EU side. There was a major decision of the European Court of Justice last week, which Jan will be discussing. And so we have a lot to get through today. But if we don't get to your question, just still put it in the queue, and we understand the organizers can put us in touch and we can try to answer that question for you separately. Okay, great. Hopefully everybody can see the slides now. So we can go to the next slide. All right, there we go. And I think we can go to the next slide now too. Great, so here's an outline of what we'll cover today. So first I'll talk about the CCPA, which went into effect in January and for which enforcement commenced this month. Jan then will cover the GDPR and recent developments, including a major decision of the European Court of Justice I alluded to, commonly referred to as Schrems 2, which I think you'll all find very interesting. We'll then compare key aspects of the CCPA and GDPR and address some ways to leverage GDPR compliance efforts to comply with the CCPA. The EU decision is particularly significant, so we'll go through some of the rest of this a little more quickly than we had planned until about a week ago to allow that time to be addressed. Okay, next slide. Okay, first to go through the CCPA. Next slide. So here's some quick background on the CCPA. So it all sprang from one person, Alistair McTaggart, who essentially said privacy is a problem and somebody should really do something about it. He didn't think privacy legislation would be enacted, so he pushed to get an initiative on the ballot in California's November 2018 election. It was really focused on the disclosure of data to third parties. He got a version of the CCPA on the ballot, and industry, fearing it would be put in place, pushed the legislature to enact a bill. And that actually happened. Some of you may have come to our offices a couple years ago. I was giving a CLE presentation and it had just been passed the day before. And so we ran through it at that time, but it was quite a hectic time. Fundamentally, the legislature had to push this bill through in less than a week to meet that ballot deadline. So if you contrast that to the nearly 4 years of negotiations that resulted in the GDPR, the CCPA was really thrown together quickly. And so that resulted in it predictably containing numerous errors and ambiguities. It remains uncertain in many ways today, even after multiple amendments and the AG issuing final draft regulations we'll talk about. So with that as background, the CCPA protects the personal information of California consumers. Personal information is defined as information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked, directly or indirectly, with a particular consumer or household. Consumers are California residents, however identified including by a unique identifier. And then a unique identifier has a lengthy definition, but fundamentally it includes device-level identifiers and any other persistent or probabilistic identifier that could be used to identify a particular consumer device. So fundamentally, the key point is it includes device level information. It's much broader than past US privacy legislation. In terms of applicability, it applies to businesses that meet certain thresholds. Essentially, a business is any for-profit entity that alone or jointly with others determines the purposes and means of processing of consumers' personal information, does business in California, and satisfies one or more of these thresholds. Annual gross revenues of more than $25 million. A loaner in combination annually buys, receives for its commercial purposes, sells or shares for commercial purposes. A loaner in combination, personal information of 50,000 or more consumers, households, or devices. This can really pick up a lot of companies. Or gets 50% or more of annual revenues from selling consumers' personal information. A business also includes any entity that controls or is controlled by a business and shares common branding with it. So you can be picked up even if you have an affiliate who meets these thresholds. The CCPA grants consumers some rights that share similarity to those provided by the GDPR. Chief among those are the right to know, the right to request access and deletion of personal information, the right to opt out of the sale of personal information, and the right not to be discriminated against for exercising one's rights under the CCPA. It imposes a number of other obligations, which we'll get to down below. In terms of penalties and relief, it provides for injunctive relief as well as penalties of up to $2,500 per violation or $7,500 per intentional violation. It has a limited private right of action. We'll talk more about that later. That primarily applies in the data breach context. Next slide. So as for recent developments, the CCPA became effective January 1st. The California Attorney General was tasked with drafting regulations to guide CCPA enforcement. The AG released final draft regulations on June 1st with highlights here on the slide. They're not official yet. I'll spare you all the minutiae of California's administrative procedures, but they'll likely will be sometime in the next couple of months. In any case, the AG's enforcement powers already began on July 1st. That's one of many ways the CCPA doesn't always make sense. To cover some highlights of the regulations, a privacy policy needs to provide consumers with a description of the business's online and offline practices relating to its collection, use, disclosure, and sale of personal information. It should also apprise consumers of their rights provided by the CCPA. The regulations say that businesses must provide a just-in-time notice when collecting personal information from a consumer's mobile device for a purpose the consumer would not reasonably expect. For minors under 13, the regulations give parental consent verification standards. This is triggered only when a business has actual knowledge that it sells their personal information to minors, not just collecting or maintaining that information. And for minors between 13 and 16, the regulations require the business to obtain affirmative opt-in consent by the minor for the sale of his or her personal information with a two-step process. Generally speaking, there are really a lot of issues covered in the regulations. There are 30 pages, but a lot of their interpretation and the way they'll be enforced is uncertain this time. It has to be borne out over time. So we can go to the next slide. So litigation trends. As mentioned previously, the private right of action under the CCPA is limited. It only applies in the case of a breach of security that results in the exfiltration of unredacted or unencrypted personal information. And so it's fairly limited, but nonetheless, there already has been a great deal of litigation under the CCPA, and we expect that will continue. The IAPP did a survey of CCPA litigation thus far last month, and they identified 13 cases involving at least one CCPA claim. In every case they reviewed, the plaintiffs include at least one claim alleging a violation of the California Unfair Competition Law. That's their mini FTC Act. It's commonly cited in privacy litigation. You can see the other statutes have been cited here too. This slide also gives some of the claims alleged thus far. Here too, we think this will develop over time. Now, 13 suits probably doesn't seem like a flood of litigation, but again, it's important to keep in mind that private right of action is extremely limited. And so we've already seen plaintiffs attempting to broaden that and to try to get around that. We expect that'll continue. And we think there's going to be an uptick in litigation when the regulations are finalized too. So now's a good time to address CCPA compliance in advance of that. So we can go to the next slide. So here we have the CPRA, CCPA 2.0. So just when you thought the CCPA was enough to deal with, Alistair McTaggart, the sponsor of that ballot initiative 2 years ago, is back with a new one, the California Privacy Rights Act. He got enough signatures for it to go on the ballot this fall, and polls indicate it likely will be approved. This actually, in some ways, is even more of a mess than the CCPA, believe it or not. It's presented to voters as a 50-page red line to an old version of the CCPA. It's very unlikely that voters will understand it, but it is likely to pass because it's going to be presented as, do you want more privacy or not? And so many voters probably will say they do. Importantly, the CCPA was a compromise among stakeholders. Alistair McTaggart originally wanted it to be much more stringent on businesses and have a very broad private right of action that would apply to all claims. That was obviated, and so the CPRA attempts to fill in some gaps and address issues that McTaggart thought were not fully addressed by the CCPA. It would make some changes that would help businesses, though, too, like broadening the scope of the exception for data that's been made publicly available. Under the CCPA right now, that only includes data that's been made lawfully publicly available in government records, which is a fairly limited set of data. Under the CPRA, the way it's drafted, it would include what we more commonly think of as publicly available data, or at least what many of our clients do, that it's any data just made available, for example, on social media. So that could potentially drastically change the law. Under the CPRA, regulations will be issued by July 1st of 2022. The law would go into effect on January 1st of the following year, and then enforcement would begin July 1st, 2023. They create a new state agency to enforce privacy laws in California. In addition to providing some new privacy rights to consumers, would extend some existing moratoria on full application of the CCPA in employment and B2B contexts. We'll talk more about those. They're somewhat limited. Some of these changes would bring California law somewhat more in line with the GDPR, but again, it's still different, and we'll talk about more of those differences later on when we contrast the two regimes. One of the other key changes, just to highlight it, it would increase the current 50,000 per year consumer household threshold to 100,000. So bottom line here, I think, is lots of changes, and if this is approved as we expect, I think we'll probably have to do another webinar, give you guys more information. Let's see. With that, I want to turn over to Jan to talk about the GDPR and developments on that front. We can go to the next slide.
Thank you, Matt. So I will entertain you about the GDPR. I'll explain at a high level the background. There's a lot in the GDPR, so I will not be able to go in a lot of detail here. The idea is to give you, at a high level, concept-wise, what the GDPR is about, or that some of you already know that to a certain extent, and then give you an update as to what is really happening in terms of enforcement, how here in Europe companies are dealing with the GDPR. Next slide, please. So the GDPR came into force a little bit more than 2 years ago. In May 2018, 25th of May of 2018 was, a specific deadline that is in privacy lawyers' minds, and that will stay there for a while, as we had to deal with, making sure that our clients were compliant or in order with the GDPR. And now we're 2 years further. The GDPR is not really a new law when you look at it. It's, of course, the idea was to modernize the legal framework and to empower individuals' privacy rights. But before that, we had a data privacy directive, and in terms of the way how Europeans regulate data privacy, there's not really a lot of difference between the GDPR and the previous piece of legislation, the directive. Only is it that the GDPR is a bit more spicy, or I would say a lot more spicy. I'll talk about that. And there are a couple of additional requirements in there that we did not have before, most notably with respect to data breach and information security. Now, the GDPR is an omnibus law. It applies to all sectors. It's a typical way as to how Europeans regulate a certain domain. It is specifically consumer-oriented. It deals with the handling of personal information in a B2C context, but also in the B2B context. It applies across all industries, whether you are a pharma company, an HR company, a tech company. You know, from the moment that you're handling personal information, you need to take into consideration the requirements of the GDPR. And it is principle-based, just as the legislation that we had before. It sets forth a couple of high-level principles like purpose limitation, proportionality, and others that I will come to explain to a certain extent. So it's kind of vague, and there's a lot of interpretation involved, which of course triggers its issues. You know, it comes with a lot of legal uncertainty, and that's why guidance of national regulators is very important to have a good practical handle of the GDPR to really understand what you need to do from a practical perspective. It's a regulation. It has direct effect. That means that every EU member state, the GDPR applies as if it is a national law. Now, at the same time, there is also implementing legislation because the GDPR does allow for some specification of certain items or allows member states to go you know, beyond the requirements that are in the GDPR. For example, when you talk about medical trials, member states do have freedom to go beyond the requirements that are set forth in the GDPR. There, the GDPR is a minimum threshold that needs to be respected, but member states can go further and provide for additional requirements. The same applies to HR privacy. HR privacy is really a field that, although the GDPR, you know, applies to it, you will want to make sure that you also take into consideration national legislation, which fine-tunes the requirements, and also because privacy law interacts with HR or labor law. You know, there you will have a lot of variation between member states. Just to give you a couple of examples. So it has direct effect, but you still will need to take into consideration national interpretations and implementing legislation. The idea of the GDPR was to come with red tape. Under the previous legislation, companies had to notify regulators about their privacy practices. They had to register their information practices. They also had to apply for permits in certain cases to, for example, transfer personal information outside of the EU. I will talk about that. There are mechanisms for that, but prior to the GDPR, you had also to apply for permits in certain countries. All of that has been abolished. So the idea is to make it more easy and to provide for less red tape. Now, at the same time, the GDPR comes with the accountability principle, which requires companies to document their privacy practices and to show to regulators that they comply with the GDPR. So all in all, I think in practice, you know, there is probably as much paperwork that needs to be done as before. It is just like more your homework that you need to do, and you need to document your practices. So you don't need a priori to show it to the regulators, but the regulators can always knock at your door and ask you to show how you comply with the GDPR. And there you have more documentation work than you had before. And finally, there are the fines. The fines are very important, not just because companies can be fined, but also in the way that we as lawyers deal with the GDPR. You know, regulators deal with the GDPR. In all honesty, before, when there were very low fines, the approach was very often pragmatic and risk-based. That is still the case. You will still try to understand what the risk is, but the level of risk is completely different than it was before. Fines can go up to 4% of a company's global turnover. So that leads to, you know, data privacy taken more seriously, certainly amongst European companies. You know, it is my experience that, and that may sound strange, but that's my personal experience, having advised companies over the last years on data privacy, that European companies took it a little bit lightly, privacy, and American companies, in my experience, are more compliance oriented and they take privacy more serious. That doesn't maybe not always resonate like this amongst regulators here, but that's my personal experience. What we see now is that companies in general, be it US companies or European companies, other companies, really have to take the GDPR more seriously, of course, because the fines are so important. Next slide. So a couple of quick facts. I cannot explain all the elements of the GDPR. That's not the purpose here, but just like some items that you may find interesting as a US audience. First of all, the GDPR has a long arm reach. There is what we call an extraterritorial application of the GDPR. If you are a US company and you do not have a presence in the EU, you may think, okay, I don't need to take care of GDPR. That's nothing for me. Well, that's not true. If you are collecting personal information in the context of the sales of services and goods to individuals in the EU, and particularly where you are targeting those individuals in the EU in order to sell them your products and services and collect their data, transaction data, what you have, well, then you are subject to the GDPR, just as if you are in the EU. So that's one element. Second is the same when you are monitoring individuals in the EU. And there is a lot of discussion what that exactly means. That requirement has been developed for companies like Facebook, Google, and other big tech companies that are specialized in tracking consumers' behavior by means of all types of trackers like cookies and other technologies. But to the extent that you make use of that type of technology and have capability to track consumers or individuals in the EU, you will be conducting monitoring. And although you do not have a presence in the EU, you risk to be subject to the GDPR. So there is a long arm reach, be careful there. Second is the accountability principle. I already explained that. It sounds like a very dry principle, which it is in the end, but basically, as a company, you need to document your practices. And if the regulator comes and knocks at your door, you need to be able to show that your privacy program is kicking and alive. It's not that matter. It's not sufficient to have a policy and put that on your website and leave it as it is. No, you need to be able to show that if consumers complain or exercise their rights, that you have acted upon these requests. You need to demonstrate that if you had a data breach, that you keep track of what has happened, that you are having a data breach program that allows you to adequately react to it, and you need to be able to show in a specific case how you have dealt with a data breach. Just to give you some examples. So in other words, you need to really in full document all the practices that you are having with respect to data privacy. And the question is, of course, how far does that go? And in investigations where we are helping clients, before DPAs, before the regulators, that's a question that all the time comes up, because in the end, the accountability principle leads to an inverse of proof. The burden of proof with the company. The company is asked to demonstrate that it complies with the law, but somehow you cannot prove that until the very end. I mean, there is always some limitation into what you can demonstrate, and that leads to interesting discussions with regulators. But the accountability principle is a very important one, and will lead to result to a lot of litigation. Your priority number one under the GDPR, it's very easy. It's information security. It's the same priority that you should have in every jurisdiction. So yes, there is a lot of things you need to do under the GDPR, but your priority number one is information security. What we see happening all the time is companies that are subject to a data breach, which is now reportable under the GDPR, and they need to notify, which they do. But in many cases, it triggers investigations. DPAs, the regulators in Europe, have become tremendously active when they, get data breach notifications. They take it very seriously, and they have organized themselves in a way that they really consider that very important and act upon it. And sometimes these are very, trivial cases, like a lost computer or, lists of salaries that are sent to the wrong recipient. But that can create a lot of trouble, because once you have the regulator asking questions, there's a risk that it doesn't end. They do have the tendency to go into fishing expeditions. That's not necessarily permissible in the EU, but it does create a lot of back and forth between the clients or between us and the regulators, and it does lead to interesting discussions that are not necessarily pleasant for companies. And finally, but I will talk about it a bit further, there are data transfers. Data transfers are also very important under the GDPR. By default, you cannot export personal information outside of the EU unless you have taken certain measures. And I will speak about the European Court of Justice decision that came out 10 days ago in Schrems 2. I'm sure some of you have heard about that. I will give you a little bit more background on that in a minute. Next slide, please. So what are the enforcement trends? I already told you to a certain extent that there is, DPAs are organizing themselves. They have more budget. They are increasingly enforcing. My practice has changed tremendously over the last 2 years. I have been advising companies for 20 years or more even on data privacy from a European perspective. And, investigations or helping clients in investigations by regulators was something that seldomly happened. Litigation was something that seldomly happened. It has happened, but not very often. Well, now 50 to 60% of my time and of time of my team is really dealing with regulator investigations, and have given you some examples. So we do see that there is a certain activism there in the market, and I don't think it will fade or go away. To the contrary, we see it's only growing. And I have on this slide put some numbers. The fines that have been imposed so far since the GDPR came into effect are $570 million US. There are 313 GDPR fines that have been imposed, and every month we follow those cases. We see that increasing, and amongst the countries that have imposed most fines are the UK, Italy, France, Germany, and Austria. But it doesn't mean that because you're in another country or you have an establishment in another country that there is lower. It is just that, of course, because there you have in those countries you have the largest companies. These are the most prominent countries in Europe. A lot of industry in Germany, the UK, and France. So it's normally that those countries have been finding the most. The type of issues that are, or that where we see most fines are, again, information security and data breaches and information security or lack of it. There's a lot of sensitivity of privacy regulators where companies are handling sensitive information like medical information and other sensitive information and are not using adequate encryption or two-factor authentication. Two-factor authentication is really something that is becoming very important in the EU. Secondly, insufficient legal basis for processing, so where companies are collecting information without notice, without asking valid consent, things like that. So that's more a theoretical matter, but that is also being enforced a lot by regulators. And then the general data privacy principles like purpose limitation, restriction of the use of data, prohibited sale or disclosure of information, that also gives rise to a lot of fines. Next. So what triggers investigations and complaints? Well, as already mentioned, data breaches are very important. VAs pick up on that, and the same with complaints. Consumers have become very aware of their rights in the EU. It has been a lot in the media, and it remains in the media. And sometimes you have something that goes wrong, a scandal that is being published, and everyone jumps on it. Regulators are required to look into complaints. They cannot just put complaints aside. They need to investigate them, even if they have limited capacity. So that means from the moment that consumers become active and file complaints with the regulators have no choice than looking into it. It is even so that in the GDPR, there's a right of action for individuals to sue regulators if they do not adequately follow up on complaints. So regulators will investigate seriously, and the numbers are there. 51% of complaints and 32% of data breach notifications are leading to investigations. The most common types of complaints are telemarketing, promotional emails, and video surveillance. So anything what deals with the use of digital technology for marketing purposes is something that amongst Europeans is perceived as not liked, or individuals are sometimes very sensitive when they receive marketing, and they may file complaints if they receive spam or unsolicited communication. So that's a domain where you need to be very careful. Regulators have reorganized themselves since the GDPR came into force. Their budget have typically increased in most countries. Typically, or the most strong examples are the UK and Ireland. There we see that in terms of manpower, the DPA Ireland has nearly tripled, and the DPA in the UK has doubled. The same for other countries like France. Smaller countries don't have such great budgets, but there also we do see that DPAs are increasingly hiring people to enforce the legislation. So that is something that is still evolving in certain countries more quickly than in other countries, but that's certainly happening, and that will continue to happen. Next slide, please. So some minutes on the European Court of Justice decision that invalidated the Privacy Shield, the Schrems II decision. A little bit of background. This is a European Court of Justice decision that came out 10 days ago and basically invalidated the US or the EU-US Privacy Shield framework, which is a framework that companies use to transfer personal information from the EU to the United States. The background on this is that we have here in Europe a privacy activist, Max Schrems, an Austrian, quite young guy, and he already was successful in attacking the safe harbor framework that preceded the Privacy Shield framework. He got that abolished by the European Court of Justice in 2015. Then the EU and the US negotiated the Privacy Shield framework that replaced the Safe Harbor framework. And Max Schrems also attacked that one together with the model clauses, the standard contractual clauses, which are EU Commission approved template agreements that companies can use to transfer personal information between the EU and other countries, including the US. So that's, there's a lot to be told about that, but long story short, the European Court of Justice abolished the Privacy Shield, which was kind of unexpected, to be honest. There were indications there was a risk, but we didn't really expect that would be the outcome. But The reasons are that the European Court of Justice believes that the US intelligence services have too broad access to personal information once it is reaching US soil, so under FISA and the Executive Order 12333. So basically, companies that are subject to FISA are believed, well, need to cooperate with, requests of the US intelligence services. And the European Court of Justice believes that those requests may be too broad and that there is not sufficient judicial control on those requests. More specifically, that individuals, EU individuals, don't have an effective legal remedy to challenge that type of access. And also, the court believed that the ombudsman, which is an ombudsman that has been put in place in the context of the Privacy Shield, where individuals can complain and have their rights enforced. It was believed that the ombudsman was not sufficiently independent and cannot, again, provide sufficient legal means cannot impose binding decisions to the US intelligence services when defending EU individuals' data privacy rights, which is true. Now, the impact is that 5,000 or more companies that have registered with the Privacy Shield need to look for an alternative. There is not a grace period, and companies need to look for an alternative. The alternative can be the use of model clauses, because the model clauses, which were also attacked by Max Schrems, those remain in force, so they can still be used. However, the court decided that they don't have the legal, they're not, how can I say, they're not an absolute protection as they were before. Companies need to make sure that the data importer, for example, in the US, can comply with its obligations under these data transfer agreements. And more specifically, also for companies that are subject to FISA, that comes with the same concerns. I mean, if again there you are obliged to disclose a lot of information without sufficient legal remedies for individuals, that potentially will create also issues under the model clauses. So model clauses are a fallback solution, but not necessarily for every type of business. If a business is subject to FISA, it may still be exposed to legal uncertainty. So that is really what happened. And what are the options? The options are already mentioned: model clauses, binding corporate rules, which are policies that are negotiated with privacy regulators to exchange personal information between companies that are member of the same group, so for intra-company data transfers. And then there are derogations that you have in the GDPR. You can, for example, transfer personal information based on consent, or because it is required for compliance or to comply with contractual obligations in the context of contractual obligations. But these are very specific derogations that do not really accommodate bulk transfers, which companies do. So that is the current situation we are in. Next slide. So the same RTCs, I already talked about that. In practice, what are companies doing? What we see, the decision is just 10 days old, but what we do advise companies is to consider the options. And the options are model clauses, and come up with an assessment and a process to make sure that you can show to regulators that the model clauses are a decent solution specifically for the data importer. Typically there are 3 layers that we add in the assessment, or that we are developing. We are in the process of coming up with a strategy, in all honesty, because everything is so new. But the first idea is, okay, if a company is not subject to FISA, that's a good thing, because that means that, you know, it can be argued that it will not be subject to bulk access requests. If it is, well, it doesn't mean that you cannot rely on the model clauses. You can still rely on the model clauses, but then you need to make sure that you have a process in place that, you know, if there is an access request, that that request is being escalated, for example, to the privacy office or the DPO, and that it is being assessed and that it is being challenged to the extent it can be challenged, but that there is some process in place in order to kind of balance the request by the US intelligence services with the privacy rights of individuals. And thirdly, is to consider technical solutions. If you can encrypt data after transfer, that's something you can consider. Also data localization, if you can keep certain information outside of a jurisdiction, outside of the US or another jurisdiction, that can also be an option. It is not, of course, an easy solution. And you know, we are certainly not promoting that, but in certain contexts, that may be a measure that helps reduce the risk to which companies are exposed. Next. So what can we expect when it comes to data transfers for the future? Well, besides the fact that companies need to reconsider their data transfer strategy, they will also need to look into their vendors, because you may use vendors that transfer data from the EU to the US and other countries. So you want to make sure that you know, your vendor is compliant with this new judgment, because companies under the GDPR are jointly liable with their vendor for the wrongdoings of their vendors. So if a vendor they have hired is not compliant with GDPR, then the company is also liable vis-a-vis the individuals and the authorities. So it's important as a company to have a look at your vendors who are in the US or in other countries, and to make sure that, you know, their data transfer solutions are under revision and are taking into consideration this new judgment. And that will be something that will take a lot of time, and a lot of clients are scratching their head how exactly to do that. But you know, that's something that is really important. Thirdly, EU regulators will certainly increase enforcement when it comes to data transfers. Some DPAs take a more pragmatic position, and we expect that they will give companies some time. But we see also already regulators in the market telling that, you know, they really think that the privacy shield or that transfers in the privacy shield should immediately be stopped, and that model clauses should immediately be reassessed, and you know, that companies should do that assessment that I came to explain. For example, the DPA of Berlin has been very strict on that and is heavily promoting data localization. Now, that's just a very extreme example. I'm not saying that every regulator in the EU is reacting that way, but you know, everyone is positioning themselves, and we do expect that at some point in time, the European Data Protection Board, which represents the national privacy regulators, will have to take position there and come up with a solution that is, you know, more accommodating for companies. And having said that, we know that the European Commission had a plan to refresh the model contracts, model clauses, and I would expect that that will happen now very quickly, because that may help again, you know, companies to rely on a new type of model clauses, which is stronger and which further takes into consideration the concerns that European Court of Justice had. I'll stop on that one because I'm sure you may have questions, and I want to make sure we have more time for that. Just on the next, very quickly, what lies ahead: increased enforcement, data breach and information security, data subject rights, and data transfers. I already mentioned that. Everything what relates to ad tech and marketing is something that remains very sensitive, and artificial intelligence. I'll stop here and give Matt a bit more time. If you have questions, happy to give you a bit more background on that one. Matt?
Great, great. Thanks, Jan. So we can go to the next slide, please. And then there's further reading and keep going. There we go. And then we can go to the next slide too. So, you know, we wanted to give enough time to go through that Schrems decision and for Jan to discuss the issues. That's an incredibly impactful decision that frankly was a little bit unexpected and will impact a lot of companies. So we want to make sure to cover that. And as he mentioned, we'll be able to answer questions. So what we'll do in the rest of the time, we know it's a little bit limited, is we want to compare and contrast in some respects the CCPA and GDPR. And then at the end, we have some ways you can leverage GDPR compliance to comply with the CCPA. Those slides at the end are fairly detailed. So if we, again, get a bit short on time, we've tried to make them useful on their own. And we'll be able to answer questions too. So we'll be looking at scope, what data is covered, disclosures, access and deletion rights, selling and disclosing data, and again, the contrast between penalties and private rights of action under these two regimes. Next slide, please. First, we'll talk about scope. Now here again, we try to make these slides fairly detailed so it'd be useful for you guys outside of the presentation. But the fundamental point on the CCPA side, I think, is that we've talked about the thresholds. A lot of companies are going to hit those thresholds unexpectedly because of the device data that is covered. And so it's not very hard to collect California consumers' personal information if that is at the level of just 50,000 devices. That's not very many per year. So even websites could cover that. We've brought up some examples of even things like very small businesses, snow cone vendors, things like that with the website would actually hit this threshold. So it was intended to provide some measure of comfort to small companies, but in practice, it'll still pick up a lot of companies. The other important thing to keep in mind is that it covers the personal information of California consumers, but in practice, that definition is not defined by reference to an individual's relationship to the business. It is just if they're a consumer generally. And so the way that's been interpreted by the AG and otherwise is that it does include B2B personal information. It does include employee personal information too, because they may not be a consumer in the context of that business, in the context of that company they work for, but they're a consumer generally. So it does apply to B2B data, it does apply to HR data. There are current moratoria, you can see them reflected on the slide through the end of this year. With respect to some aspects of handling HR and B2B data. The CPRA, as I mentioned before, would actually extend those moratoria until 2023. So that's one of the ways it would be helpful if it passes. There's some thought too that those would be extended if for some reason the CPRA does not pass. Jan, do you want to contrast that with the GDPR?
Yeah, just very quickly here, from the GDPR perspective, we don't have those thresholds. The GDPR applies to the processing of personal information wholly or partly by automated means. So from the moment you're touching upon personal information, personal data, which is very broadly defined, you will be subject to GDPR. It applies to companies or organizations in the EU. As I already explained, there's the long arm provision. So also if you were in the US. And it applies to companies that control the data, that decide on the purposes and means, that own the data, and also it provides for provisions for vendors or processors that handle personal information on behalf of other companies. It applies to all types of information, B2B, B2C, employee data, in all sectors I explained, and it has been entered into force already more than 2 years.
Right. Okay, next slide, please. So the scope of data. So again, I've been alluding to aspects of this. I don't think we need to go through this in great detail. I think the interesting aspect is, again, this is the first US law to have this, frankly, GDPR style concept of covered information. Most pre-existing US statutes covered a much more constrained set of personal data. There were things like name, email address, The Federal Trade Commission and state regulators over time had migrated toward attempting to regulate device level data in a variety of ways, but this is the first statute to really do it in a clear way. Interestingly, there's a concept of household data. We wanted to clarify in the slide, there had been some thought initially that household data would just include, even just address information or anything about a household. It was clarified that it's intended to include, you can see the elements here. It's got to be people who reside at the same address, they have a common device, and they're identified as having a common account. And so really it's intended to cover household accounts for things like, you could imagine Netflix and the like. That's what it's intended to cover. Jan, you want to contrast that?
Yeah. So, I mean, in the EU, as you can see, the definition of personal data that is covered is also very broad, if not even broader. Only information that is truly anonymous is not regulated by the GDPR. And what is really truly anonymous becomes more and more, it's a smaller domain with AI. I mean, AI more and more has the capability to combine data sets in a way that was unimaginable before and to re-identify individuals. Also pseudonymized data, if you have a data set where you replace the name and the identifiers by a code, that is also covered by the GDPR. Very quickly you will be in the scope of the GDPR, and it's difficult to escape it.
Yeah. Next slide, please. So consumer disclosures, I think the best way to cover this in this context is, again, we've laid out here the kinds of disclosures are required under the CCPA and the GDPR respectively. I think the key point in the context of this presentation is just they are in some respects similar, but it has to be a jurisdiction specific approach. The CCPA disclosures are fairly specific when it comes to what has to be disclosed. And then I think, Jan, if you want to talk about the GDPR, I think those are also, frankly, idiosyncratic to the GDPR.
Yeah, and they are very important, because they are seen as the basis for individuals to exercise their rights. As an individual, you need to know how your information is being used and handled in order to enforce your rights. So, having disclosures correctly written and duly published is very important.
Right. Next slide, please. So, access rights. Again, here, I think a fundamental point with the CCPA is this is really the first US statute that has these rights that come from, they're similar to the GDPR. But again, they're discrete and they're limited to the CCPA. They're focused that context. So a bottom line, which I think we'll get to at the end when we talk about ways you can leverage compliance, is you can substantially leverage, for example, your processes and procedures for responding to data subject requests under the GDPR with the CCPA. But it's important to look at them and make sure they actually make sense with respect to the CCPA, because you can see here there's some similarities between these, but they are also distinct. You have to make sure you're complying with each regime. It's not as simple as just applying it company-wide. Jan.
Yeah. Just that's a very good point. And just to add one point, those rights in themselves are very straightforward, right? Access. What is challenging is to put a process in place as a company to operationalize those rights. If you have an individual exercising its rights of access, well, you may have structured data, but you may have a lot of unstructured data sitting in emails and at random databases. And how would you deal with that? I'm not going to answer that, but having a due process to operationalize those rights is something that is challenging but very important.
Right. Next slide, please. Deletion rights. Sticking with the same theme, but perhaps even more so in some ways. The deletion right, it is similar. There is, as is famously known, a right to be forgotten under the GDPR, which Jan can speak to, and there are other deletion rights. But under the CCPA, there's a right to request deletion of personal information. It's subject to numerous exceptions, though, that we can't cover here. But here it's just very important to make sure that your deletion procedures are tailored to the CCPA, because there are 9 articulated exceptions, and they're frankly detailed and too difficult to get in this context. But you have to make sure you're telling your practices. Also, as discussed here, you have to make sure you instruct your service providers to delete personal information of the consumer. If you get a verifiable deletion request, you have to make sure you, as a business, not only respond to that, but instruct your service providers. Jan, anything to make the
concerns are the same from the European perspective. Yeah.
Okay, and I know we have to go a little faster at the end. We want to get through this for you guys. Next slide, please. So, sale and disclosure. This is interesting because the CCPA, it was really premised on the sale of personal data or personal information. That's what it was put in place to cover. And so the GDPR doesn't have a concept of sale per se, and Jan will talk about that. But the CCPA does, and that's kind of what it's all centered around, or at least originally was. I think the key point to make sure people understand is it's not really a sale in the sense that we would typically understand it. It would include things like putting a tracking cookie on your website or on your mobile application or on your online service that would be disclosing that data to an advertiser who's functioning as a business. So the sale definition can wind up being extremely broad. And so you just have to make sure you're analyzing that extremely carefully. A lot of companies mistakenly think it is actually just a sale in the traditional kind of data broker sense. It's much broader than that.
Yeah, from a GDPR perspective, the sale of data is not specifically regulated. You will not provide a specific provision in the GDPR dealing with that. It is not specifically prohibited, but there's, as you can imagine, a lot of sensitivity towards the sale of information. You will need a specific legal basis, and that will most often be consent, which needs to be informed. There is also the expectation that individuals are informed to whom data may be sold. Specifically in France, the CNIL, the French DPA, has issued specific positions there, and the approach is very restrictive. But it is possible under certain very restrictive conditions. One more item to add is when you're dealing with sensitive data, then it becomes really very difficult and very risky. So, kids' data or health-related information, although not explicitly prohibited, will most likely never be accepted by regulators in the EU.
Right. Next slide, please. So I've alluded to this before, but just to cover it quickly, the private right of action under the CCPA is very important, but it is limited. It is only applicable in the context when there's non-encrypted and non-redacted personal information and subject to unauthorized access and exfiltration, theft, or disclosure as a result of a failure to maintain reasonable security measures, which otherwise is required by California law. It also requires that notice be given to the business prior to suit. So you have to notify the business, give it 30 days to, quote, cure the violation. Now, one of many things that's yet to be determined under the CCPA and under these various litigation matters will be what it means to actually cure a data breach. We speculate it likely would include some kind of means of making consumers whole. Importantly, though, the 30-day notice provision only applies to those who are only seeking statutory damages. If consumers have actual damages or otherwise asserting that 30-day notice requirement does not apply and the cure period does not apply. So it's a bit of a messy situation. Again, so far we've seen litigation. We can expect to continue to see whenever there's a data breach and that data is not encrypted or redacted. So the key message is to try to encrypt and redact personal information of California consumers wherever you can. Yeah.
Yeah, in the EU, individuals have obviously the right to file complaints with the regulators, but also right of action before courts to claim damages if you know they have incurred damage where a company is violating the GDPR. We also have class type actions. We don't really have class actions as you have in the United States, but under the GDPR, NGOs or consumer organizations can make claims of individuals and you know, lodge a complaint on their behalf before the regulators or before the courts. And that's something that we see increasingly happening also in the context of data breaches. For example, in Germany, lawyers can collect claims and then represent those individuals in court and claim for damages.
Yeah, next slide, please. Let's see. Here we go. So I think, yeah, there we go. So as it says here, the AG has the exclusive authority, other than that private right of action, to fine businesses for violating the CCPA. The penalties here, they don't seem, they're certainly not as staggering as the EU penalties, which Jan will discuss, and I think many of you are probably familiar with, but they certainly can add up. I mean, a violation in this context can be typically asserted to be each individual or data record that is compromised. It's not an event of a violation. So if a data breach occurred, for example, and it affected 100,000 people, it'd be 100,000, multiplied by these numbers potentially. So the numbers can wind up being very large as well. Yeah. Jan, you want to talk about the GDPR?
Yeah. As you know, the administrative fines and the GDPR can be high, up to 4% of a company's global turnover. So you have administrative fines and you have civil damages, and then thirdly, member states in the EU may also provide for criminal sanctions. For example, in the UK, it is a criminal offence for a data processor to violate the controller's instructions. Or in other countries, certain violations of the GDPR or the implementing legislation can lead even to imprisonment. So there are 3 levels of enforcement.
Right. Okay, next slide, please. Great. Okay, so finally we want to go through, and I think we'll go through this again extremely quickly because a lot of it is just able to be ascertained from the slides, but we'll go through. You can leverage certain GDPR compliance efforts to comply with the CCPA. Previously, a lot of companies thought they could simply port those measures over. You can take the underpinnings, but they have to be tailored. So we'll go through the process quickly. You should review your current data maps and inventories, amend disclosures as needed, assess the efficacy of your current data subject requests, mechanisms for access and deletion requests, and then evaluate your contracts with service providers. Next slide, please. And here, this is, this can be very quick, but the fundamental, the first step in any of this is to take a look at your data maps. So if you've gone through GDPR compliance, you should have data maps and data inventories. Those can be leveraged in certain cases, but it's important to address key considerations. So do they include data that's personal information under the CCPA, but might not be under the GDPR, or vice versa? Because the definitions are similar, but they're not quite the same. You have to make sure they're right. Do they include personal information of California residents? Do they include adequate coverage of all the categories of personal information, the sources from which the data is obtained, and the categories of third parties to which the data is sold? And then fundamentally, again, because of that difference between the regimes and the focus on sales in California, is there enough information in the data map to ascertain whether there's a sale of data? That's the key point. So in practice, what I think a lot of companies can do is they can take that data map, they can tweak it in some ways and expand it. And that's what we've seen a lot of companies be able to do. But you can't just port it over necessarily. Next slide, please. So consumer disclosures, Again, I'll just talk on this quickly. It's important to review all these, including the notices of the point of collection and privacy policies, to make sure they meet the CCPA's requirements and to make sure consumers can exercise their CCPA rights. Importantly, you want to make sure you understand whether the business, again, is selling personal information. That's a broader concept than people think. And if so, you have to have a do not sell my information disclosure and an opt-out mechanism on the website. I think a lot of you will be familiar with that, but it's important to make sure you're familiar with that, because you actually have to have a do not sell my personal information link on your homepage if you're a business operating in California, again, as of July 1st. Jan, anything you'd want to add from a consumer disclosure standpoint? I know, again, Shrem's may be relevant to that too.
Sorry,
oh yeah, anything you want to add to that? Just any need to review disclosures in the GDPR?
Yes, I mean, from a data transfer perspective, of course, in the EU, you need to mention the legal basis for transfers. So, given the court decision, you will also need to update that and make sure that you mention your amended data transfer strategy in your disclosures. Yeah.
Okay, next slide, please. Here too, just quickly, we've talked about these, but if a business has effective procedures to respond to data subject requests under the GDPR, you probably can leverage those, but you have to do a gap analysis, make sure it corresponds. Typically, they have to be modified in some ways to fit the CCPA's requirements. Also, typically, you're going to have to do some additional personnel training and awareness initiatives. People in the US, they're not accustomed to dealing with these issues like people are in the EU. As Jan mentioned, even before the GDPR, there was the Data Protection Directive and the member state implementations of it. And so there's a long history of people being familiar generally with EU data protection requirements, although they were broadened with the GDPR in many ways. But in the US, the CCPA is completely new, and many companies just are not used to it, and their employees are not used to it. Next slide, please. So final slide here before we get to the end. And a key thing that a lot of companies are having to do is you need to evaluate and update your contracts with service providers. You'll hear this referred to as DPAs, having the right DPAs in place. It's important under the CCPA to make sure that they do what you need them to do, which is to make sure the service provider is prohibited from selling the personal information shared between the parties. They can't retain, use, or disclose personal information for any purpose other than performing the service provided for in the contract. And they can't retain, use, or disclose personal information outside of the direct business relationship with the data provider. The CCPA also has a bit of an odd requirement. You need to require service providers to include a certification that they understand and agree to the terms. So again, you probably would not have that in your existing GDPR DPAs. It's one of the just kind of little things you have to modify. Fundamentally, what we see in practice is companies can typically take a GDPR DPA, they can modify it slightly, but we typically require or recommend a separate set to address CCPA specific concerns. And that's what we've seen a lot of companies do. I think you'll see some companies that rely on GDPR DPAs in practice, but typically we recommend that companies have discrete CCPA DPAs. That's the end of our slides. Before we get to the end, you can go to the next slide, please. Just the closing slide. Jan, anything else you want to add at this point? I know we want to address any questions people have, but I know we're over time as well, which I apologize for.
No, I'm happy to take any questions.
Okay. Let's see, look at the Q&A tab. Looks like we don't have any open right now. If you have any questions, just let us know. Again, I apologize for some of the latter portion of this being rushed. We wanted to make sure we covered everything. We also wanted to make sure we gave adequate time to Jan to talk about that Shrem's decision. That's, again, it's an impactful decision. It's the first decision on that front since 2015 when the safe harbor was invalidated. So it'll impact a lot of companies. We hope this is helpful. If you have any questions, let us know. We'll be glad to answer.
We did get a quick question from Paul. What steps can you take to verify data subject is in California?
Yeah, there is no clear guidance on that front, but typically it would be like you would attempt to ascertain whether data subjects are in a jurisdiction for any kind of multi-jurisdictional analysis or analyzing whether you're subject to local law. So things like geolocation, looking at IP addresses. If you have the kind of business where you're, of course, collecting contact information, trying to ascertain whether they're located there. In practice, of course, if you just have no means of ascertaining that, and you may just have to look at the nature of your business and just try to assess, because it only applies to California residents. So if you, for example, only collect personal information from 70,000 consumers, it may be unlikely that there would be 50,000 of those in California, depending on, of course, the nature of the business. Okay. Well, thanks everybody. If there's any other questions, just feel free to share them with the organizers or contact us directly and we'll be glad to help. But thank you very much for taking the time to join us today.
Thank you.
Thanks, Jan. Thanks, Matt.
Absolutely.